Hello. ওরা বলেছে কোন কোন রিপোর্ট
Yes, sir.
Wait, please, Lord. My Lord, I have got only a few more judgments to deal with. Then, my Lord, I shall finish my submissions. My Lord, the next judgment, my Lord, cited, I think, by Mr. Mukherjee, is, my Lord, 2008 4 Supreme Court cases 451. The case of B.K. Muniraju versus State of Karnataka. Page 451. Well, this is, I do not know, your Lordship has got, well, I don't know, well, how it is relevant in this case. Well, this was a case of certiorari right, not a case of mandamus at all. This is a case in which, well, kindly come to paragraph 7 of the judgment at page 453. Based on the said direction of the High Court, the Assistant Commissioner heard the matter afresh. Finally, the Assistant Commissioner dismissed the matter, holding that the land in question is not a granted land, but was purchased by so-and-so in public auction. Then, para 8, questioning the said order of Assistant Commissioner, the appellant herein preferred an appeal before the Deputy Commissioner. There was, my lord, this departmental proceedings, my lord. There's a complete code as to how, my lord, the matter will be decided. And then, my lord, Assistant Commissioner decided the matter. The writ petition was filed challenging that this is by way of certiorari. Well, I don't know, my lord, in our case, my lord, there is no question of any decision by any authority which is sought to be challenged by me. So, my lord, this judgment has got no application whatsoever. Kindly come to paragraph 22, then it will be clear. After discussing, my lord, everything with regard to the factual part of it, with regard to certificate of granted land, etc., the court says this, para 22, it is settled law that a writ of certiorari can only be issued in exercise of extraordinary jurisdiction, which is different from appellate jurisdiction. The writ jurisdiction extends only to cases where orders are passed by the inferior courts or tribunals or authorities in excess of their jurisdiction, or as a result of their refusal to exercise jurisdiction vested in them, etc. Well, this is with regard to, my lord, the questioning the jurisdiction of a tribunal which has been constituted, my lord, by an under a statute, and a statutory proceedings were initiated. In connection with that, my lord, these observations were made. My lord, I submit to your lordship, it has got no connection with, my lord, the mandamus proceedings, where I am challenging, my lord, the arbitrary action of the authorities concerned, whether it is Calcutta Municipal Corporation or, my lord, KIT or, my lord, Government of West Bengal. So, my lord, I submit to your lordship that this judgment has no application to the facts of our case. The next judgment was, my lord, D.D. Sharma versus Union of India, reported in 2004, 5 Supreme Court cases 325. This also, my lord, I am unable to understand, my lord, the relevance of this judgment. This judgment is an arbitration matter. And, my lord, what was held in this is, it is just laying down the duties of an arbitrator, namely, my lord, that he is to, when he is deciding a matter on the facts of a case, he is to look into the correspondence between the parties. So, well, I don't understand, my lord, how it is relevant in the facts of this case. This is purely a case of Arbitration Act. And, my lord, what was questioned was that the arbitrators did not take note of the correspondence which passed between the parties, which had given the foundation for his jurisdiction and his finding. Therefore, my lord, I submit to your lordship, this has got nothing to do with our case. Therefore, my lord, I am not troubling your lordship with this. Then, my lord, the
So
next.
do you have a copy of that?
Yes, my lord, I have got a copy. I shall hand up to your lordship. This is your lordship is talking of D.D. Sharma. This is 2004 5 Supreme Court cases. Yeah. I've got a copy. Your lordship can keep this. This is a judgment, I think, cited by Mr. Mukherjee, if I remember correctly, or maybe Mr. Dotto. I'm not very sure who cited this, but I didn't find any relevance of this case. This is laying down the principles which, my lord, we use in arbitration matters as to the jurisdiction of the power of an arbitrator, powers and duties of an arbitrator, as to how he is to proceed. So, my lord, I submit to your lordship, these have got no application. I am quickly disposing of this. My lord, the next decision cited of a Telangana High Court at Hyderabad, reported in 2023's SCC Online TS 628. This is a single bench judgment of the Telangana High Court, where, my lord, if your lordship looks into it, this is called Advanced Mining Technologies Private Limited. এটা এইরকম ভাবে দেখতে, এটা ওরা কপি দিয়েছে, এটা তোমারটা অন্যরকম, এটা ইন্ডিয়ান সিভিল কেস, ওরা কি ইন্ডিয়ান সিভিল কেসে দিয়েছিল, ও তাহলে এইরকম হবে, তাহলে
দেখেন আছে মনে হচ্ছে
হ্যাঁ ওইটা, that's right, that's the one. Well, in this case, it was a pure money claim. And the court said that it's really a suit should have been filed for the purpose of claiming this money. So if your lordship looks into the paragraph, I don't know, my paragraph will not tally with your lordship. Copy আছে? দেখো তো paragraph 6. The learned Singh, yes, kindly come to paragraph 6. This is a purely contractual claim. There is no public element involved, and, my lord, just a claim for money. Kindly come to paragraph 6. The learned senior counsel for the petitioner further submit the contract number 2 was completed on 8/11/2021, and the bills were raised on 25/11/2021. On presentation of the last bill, the total amount due to the petitioner was 7 crores 50 lakhs and odd. Then, my lord, the respondent corporation sent a letter dated so-and-so, informing the petitioner company that the entire payment was withheld against the settlement of future interest amount on mobilization advance, against the said illegal and arbitrary series of actions of the instrumentality of the state to deduct future interest on already deducted amounts that are secured by the bank guarantee. The petitioner is constrained to file this writ petition. So pure money claim. And, my lord, kindly come to one paragraph. Your lordship sees here the ABL International has been considered. Then, my lord, the cases I cited, Joshi Technologies International, etc., have been cited. Then, my lord, paragraph 20 is Joshi Technological, which I cited before lordship. That paragraph 69-70 had been quoted. Then, para 21. In view of the above settled proposition of law that the dispute relating to the terms and conditions of contract with regard to money related may not be permitted to agitate in a writ petition under Article 226 of the Constitution. Here I am not making any money claim at all. There is no question of any money claim. And I am questioning, my lord, the action of the, my lord, of the municipal corporation in withholding the plan, sanction of the plan. I am questioning, my lord, the action of the KIT, the Kolkata Improvement Trust, for, my lord, giving direction not to pass the act, pass the plan. And I am also questioning the government of West Bengal's very high-handed action in cancelling the registered lease. This is all. So, my lord, this judgment also, in my very respectful submission, does not help my learned friends. Then, my lord, the next question is Supreme Court judgment. This is 2023 SCC online SC 450. এটা কি এইবার কি ইন্ডিয়া ইন্ডিয়ান সিভিল কেসে সাইড করেছে? আমার ইন্ডিয়ান সিভিল কেসে নেই। এটা দেখতে পেয়েছেন? হ্যাঁ, থ্যাংক ইউ। Well, the judgment of Justice Ajay Rastogi and Justice Bela Trivedi. Now, my lord, here, your lordship will please to see is a mandamus to execute a lease deed. This has also, my lord, has no application in these facts of this case. Can you see what the Supreme Court had said? Kindly come to paragraph 6. First of all, my lord, kindly see paragraph 4. It is not disputed that the respondent deposited total sum of rupees 2 crores 2 lakhs from September so and so. My lord, kindly come to para 2. I think that will be easier. Paragraph 2. This is the facts of the case. My lord, the facts of the case carved out from the record are that the appellants, according to the land disposal rules, issued an advertisement and invited bids for grant of lease of different plots under the Transport City scheme. The respondent was also one of the bidders in so-and-so market plot of 50 square meters, etc. The offer of the respondent of 727 per square meter being the highest bid was finally accepted. Consequently, a letter of allotment dated 29 September 1997 was issued in favor of the respondent, whereby it was informed that the bid of the respondent was found to be the highest and it had been decided to lease out the plot area of so and so in his favor for a consideration of rupees 2 crores and odd. Then, my lord, how the money is to be paid, that has been set out. Then paragraph 4 is saying how the respondent deposited the various sums of money. Quite a substantial amount had been deposited. And then, my lord, kindly come to para 6. This is all very well. This what was settled between the parties with regard to the lease of a particular plot of land. Then, my lord, after more than a period of 3.5 years, the writ petition came to be filed by the respondent under Article 220 of the Constitution, seeking a mandamus against the appellant to execute the lease deed for the remaining area of 9,625 square meters, in addition to the lease earlier executed. So, my lord, the contract was for execution of lease and payment of certain sum of money. After more than 3.5 years, the writ petition was filed. Why? For the purpose of getting some additional land at a certain sum of money. And this is what was filed, and that has been recorded here. It is in addition to the lease earlier executed in favor of the respondent. And the division bench of the High Court, while accepting the prayer made by the respondent, directed the appellants to execute the lease deed in favor of the respondent for the remaining area of 9,625 square meter, for which there was no agreement at all. So this is what was asked for, and this was what was granted by the Madhya Pradesh High Court. Then kindly see, my lord, what the court has said after discussing everything. Your lordship, kindly come to para 19.
Yes.
The High Court, under impugned judgment, has although passed a very lengthy order, but the judgment on which reliance has been placed have no semblance of the facts of the instant case, and natural justice has no role to play in the given facts and circumstances of which reference has been made. In our considered view, the judgment passed by the High Court in issuing mandamus to execute the lease deed in favor of the respondent for the remaining area of 9,625.50 square meters is completely beyond the jurisdiction, and such direction, in our view, being contrary to the law, deserve to be set aside. And then it goes on to say, para 20, the submission made by the respondent that the tender floated by the appellant on 13 March 1997 was called upon the bidders to submit their bid of 27,000 and odd meters of square meters, which could not have been segregated, more so after a bid had been finalized at the rate of rupees 725 per square meter, and that alone has been taken care of by the High Court by directing to execute the lease deed for the remaining of the land, in our considered view, is bereft of merit for the reason that so far as the tender floated by authority on 13 March is concerned, the transaction was concluded on execution of the lease deed executed without demur for 18,000 and odd square meters on so and so. And after the transaction is concluded and the instrument being registered under the law, it was not open to either party to question, at least in the writ jurisdiction of the High Court under Article 226 of the Constitution, and the mandamus issued by the High Court to execute the lease deed for the remainder of the area without any consideration is completely contrary to the settled principles of law and deserve to be set aside. Naturally, my lord, I say that an agreement is made out, execution is completed, registered document is made with regard to X quantity of land, money has been paid, everything is complete. And then, my lord, 3.5 years thereafter, the party concerned comes up that you also give me lease in respect of Y, for which there was no agreement, nothing of the sort. And the Madhya Pradesh High Court said that yes, you are entitled to get that. And that was done by a writ petition. And that was, my lord, struck down by the court. So therefore, this case is a glaring case of, my lord, if I may respectfully submit to your lordship, glaring case of, my lord, completely misunderstanding the scope and effect of Article 226 and the scope and effect of the agreement between the parties. If the parties had agreed with regard to X quantity of land, how can, my lord, the court go ahead and, my lord, give also, my lord, with regard to Y quantity of land without there being any agreement to that effect? This is what was struck down. Therefore, my lord, this also will not assist my learned friend, my lord, where I am relying wholly on a registered document between the parties, under which they are to discharge certain duties which they have failed to discharge. And without discharging that duties, they have purported to cancel that on a ground which is not available to them. This is my short case. Therefore, my lord, this judgment will have no application in my respectful submission. Then, my lord, the last judgment, my lord, that was cited, I shouldn't say last judgment, there is another judgment I shall indicate to your lordship, 1945 Privy Council. But before that, 2023, 20 Supreme Court cases, page 655, Shakil Ahmed's case. এটা আছে তো, এটা কপি নেই আপনাদের, এটা সাইড করেছে তো ওরা? ও না না, তাহলে একটা কপি দাও তাহলে জজ সাহেবকে। Well, may I hand up to your lordship the copies? But then my copy is, my lord, not only marked, also, my lord, there is an observation at the top. My lord, I tell you, lordship, what this step, I shall hand up to your lordship my copy. তোমরা কপি দাওনি কেন? এটা তোমাদের একদিন তো কি করেছে? This is 2023 20 Supreme Court cases, page 655. Shakil Ahmed versus Saeed Akhlaq, Justice Vikram Nath and Justice Rajesh Bindal. This was a case of sale of property under Section 54 of the Transfer of Property Act. And, my lord, the document was not registered. The short question was, if the document was not registered under Section 54 of the registration of the Transfer of Property Act, could it pass title? The Supreme Court said no, it could not pass title because the Section 54 read with, my lord, Section 17 of the Registration Act read with Section 49 says that if you want to transfer title, you will have to have a registered document. This document not being registered, short point. Therefore, it did not pass title, Section 54. Well, my respectful submission is our case is not, my lord, sale of land. The reason why I am making this distinction is, your lordship remembers, my lord, that judgment of, my lord, Ithu, that judgment I cited, that in respect of a lease, there is a, so to say, a distinct, I should say, bifurcation of two states of affairs. First is unregistered lease for a long period. Court says that even though it requires registration and the lease did not create any interest in terms of that lease deed, but because of Section 105, read with Section 107, a monthly lease is created. An interest is created in the land. That interest continues until you put an end to it in terms of section 106 of the Transfer of Property Act. It goes on further to say that if that lease is fructified into a registered lease afterwards, then the registered lease comes into operation. Then, my lord, section 106 will not do, then section 111 will have to do, for the purpose of putting an end to them. The distinction in between, my lord, a registered lease for the purpose of transfer of title under section 54 and, my lord, registered lease in terms of, my lord, section 107 of the Transfer of Property Act is, the basic difference is this, that in respect of a lease, a monthly tenancy is created, which concept cannot be, my lord, in respect of a transfer of property. When I am selling a property to my learned friend, I will have to have a registered deed. Otherwise, my lord, he will not get any title at all. He will be with zero title. Whereas if with an unregistered lease, if I transfer it to my learned friend, he will get a monthly tenancy. And that is what, my lord, those two judgments I cited.
So this is concerned with sale, as you said?
Yes, absolutely. This is concerned with sale. This is not really impinging on the issue that I have adverted to your lordship. So, my lord, I submit to your lordship that this judgment, if I may hand up to your lordship a copy of it, and kindly do not mind, my lord, my marking. তোমরা একটা কপি দাও নি বলে আমার কপিটা দিও দেখালাম. Yes, lordship will please, your lordship is pleased to see this, that section 54 of the Transfer of Property Act, that is the subject matter of it. If your lordship comes to paragraph 2, the appellant is the defendant in the suit for possession. I am grateful to my grandson for giving this to me. I am not still used to using this. I am an old-fashioned person. But he seems to have learned much faster than I have. The appellant is the defendant in the suit for possession and mean profits instituted by the respondent with respect to the property in question. The suit was filed on the basis of a power of attorney, an agreement to sell, an affidavit, and a will executed in favor of the respondent. The appellant admittedly was in possession of the property in question. The suit was contested on several grounds: that the appellant was the owner of the property, having received the same on the basis of a hiba, oral gift, from its owner Laik Ahmed, his own brother. Secondly, the suit was not maintainable as none of the documents on the basis of which the suit was filed were either admissible nor enforceable under the law. Both led evidence, oral and documentary. So, my lord, this was on the basis of an oral gift, no registered document, and, my lord, the person who is in possession is claiming that I have become the owner of the property. See, my lord, what the court says. After, my lord, the submission.
Paragraph 10, 11, 12.
Yes, paragraph 10. Paragraph 11. Having considered the submissions at the outset, it is emphasized that irrespective of what was decided in Suraj Lamp and Industries, the fact remains that no title could be transferred with respect to immovable properties on the basis of an unregistered agreement to sell or on the basis of an unregistered general power of attorney. So there was an unregistered agreement to sell and, my lord, unregistered power of attorney. Now, kindly, my lord, see in our case, registered deed of 2010 and, my lord, registered power of attorney. There is no dispute. Factually, our case, my lord, is...
So they have raised one question.
Yes.
They have said that the lease that was registered was through the power of attorney granted in favor of the executor.
That's it.
And so how it can be done in that sequence? Means a power of attorney holder is signing in his individual capacity as well as executing them. That is what they pointed
Yes,
out.
quite right. ঠিক আছে, আর দরকার নেই। আর লাগবে না। This is with regard to the sale of a property. I am answering this. My lord has been pleased to ask me the most pertinent question. This is the question. My lord,
So let us first complete the case laws.
this is the last decision cited.
No, sir. What I'm saying is, you have any more matters that they have cited? You have to.
1945 Privy
Yes,
Council.
let us finish that. Then we'll
Very
come
well.
to that question.
Very well. 1945 Privy Council. And this is, my lord, the same question. No document required to be registered shall be admitted in evidence and shall not affect the immovable property. So, my lord, what they are saying is that an unregistered document cannot be admitted in evidence and shall not affect the immovable property. This is also again with regard to the title. Therefore, I am distinguishing this particular case again on the basis of this, that in our case, there was a registered power of attorney, there was a registered deed. This is 1945. I don't have a copy of that. Then, well, dear Lordship, can you forget that, because I am told that this has not been cited. So somehow it has gone into my note.
The state police.
Anyway, my lord. So the principle and policy which is thought to be shown, my lord, is that. To that, my lord, my answer is I've already given your lordship, and I shall just tell your lordship, my lord, that what is very important in our case, my lord, if your lordship kindly takes that bundle, where, my lord, the documents are there. I shall just refer your lordship to this I would submit to your lordship the complete answer to their point. My lord, kindly come to that brief. Well, this on the basis of the question that your lordship is pleased to ask. I am seeking to answer this. My lord, kindly take. No, Judge Sahib ke brief ta gidi. Your lordship will please to take this a bundle ta ache to. Judge Sahib ka ache. Your lordship will kindly come to item 29, page 86.
Yes. Agreement to lease.
This is the registered deed of lease. The agreement to lease, my lord, is item that is in 2002. This is, my lord, item 12. 22nd February 2002 is the unregistered deed of lease at page 28. Then, my lord, we come to item 29, which I just now showed to your lordship.
86 to?
This is item 86 to 115. Once
Yes.
this is registered, this is, my lord, the register agreement of to lease, which has been registered. This is a registered document. And this your lordship will please to find.
So you come to page number 109.
109, 109. Correct.
So the issue that they raised was
That the same
that,
person.
Managing Director for MA Construction.
Yes.
As well as the MA Constructions.
Right.
So this couldn't have been identical.
Lordship. To that, my answer is this, very simple. Lordship will take their letter, the letter on which I want to rely upon. My lord, kindly come to the letter at page. Kindly come to page 85. Kindly come to page 85. When I had been asking them for that registration of the lease, what, my lord, North Bengal Transport Corporation says, kindly see. This is dated 19 January. Why was it registered by me and in my name? Kindly see what they are writing to me. MA Construction, my client. They are writing, my lord, NBSTC Kuch Bihar. Kindly come to the paragraph, last paragraph. This gives the complete answer. Accordingly, now I should say second paragraph first. However, since you have already paid 13.06 crores to NBC STC, that is more than so and so of the lease value.
Is it 50%? More than 50%?
Yes, more than 50% of the lease value, and further agreed to make payment of at least 3 or 4 crores towards the statutory liabilities of the corporation, and also agreed to make payment of the balance lease value as early as possible, and considering the situation that unless the said notarized agreement to lease is converted into a registered one, note the words, you are not in a position to progress the work. As such, the corporation has decided to accept your proposal for registration of the said notarized document. And then the next paragraph. Accordingly, you are directed, NBSTC has directed me to exercise the powers already delegated to you by the registered power of attorney, and being the constituted attorney of NBSTC, you are requested, kindly my lord, mark the word,
Authorized.
you are authorized to sign the document and present the same before the competent authority for registration of the agreement to lease dated 22nd February 2002 without any further delay. The corporation will not bear any cost or expenditure on this account. A copy of the registered document may kindly forwarded. So NBSTC, who was to give me, my lord, the registered lease, they are saying you have got the power of attorney. Therefore, exercise your right under the power of attorney, which I have given to you, and execute the.
Yes, sir, but they said that it's a notarized one.
My lord?
It was a notarized one. The registered power of attorney.
No. There's a registered power of attorney. No question of notarized.
So during the submissions.
No, but the submission is wrong. Because, my lord, kindly come to page 49. It's a registered power of attorney. I have got a registered power of attorney authorizing me to do what I have done. And this, your lordship, will be pleased to find at page 60 as also page 58. I have placed before your lordship these clauses, which authorizes me. And my lord, NBSTC, who is to, my lord, execute the lease in my favor, they are saying that I have given you the power. So why don't you exercise that power and execute a lease in your favor? So what wrong have I committed? Well, this is leading me out the garden path. Well, this is exactly, my lord, what I am submitting to your lordship, that put me on the tree and then lop off the branch. Almost like Kalidas. My lord, I submit to your lordship that this your lordship will not be pleased to entertain at all. The party who is to execute the registered lease is writing a letter that I have given you the power to get it registered. Why don't you exercise that power and register the lease? And in terms of that, very next page, my lord, I have registered the lease. So now can they question, well, principle of stop? Well, I don't know to what extent, my lord, the fairness in action should be sacrificed by the government. The government itself is saying that you register the lease by letter writing. When I am saying that please have it registered, they say that I have given you the power, you get it registered. Twofold answer, my lord, on this letter. First of all, they are admitting that the registered power of attorney contains a power to register a lease deed, number one. And number two, it is egging me on that you get the deed registered. Once I get the deed registered, my lord, it becomes their deed. It is not my deed. And they are not disowning that. Until this my lord, argument is made from the bar that the same person is executing a registration, they have not said that. Not one letter. I have given your lordship the volume. There is not one letter in which they say there is no registered lease in your favor. Because you have yourself executed the lease in your favor. They are not saying that. And that is not the ground, my lord, for setting it aside, for my lord, challenging this particular lease deed.
So they're not recognizing the registered deed.
If they are bound to recognize, because it is on record.
Their entire case rests upon the unregistered.
No, your lordship sees, my lord, kindly come to the letter by which they have purported to terminate this, cancel this. They say cancel. Kindly come to page 157A. And there is no answer has been given to mine. 3 points I have made before your lordship. First is, when there is a registered lease, you cannot terminate it just like that. You'll have to comply with the provisions of law. Transfer of Property Act, Section 111. You have not done that. There is no answer to that. Number two, before you cancel, your purported cancellation does not contain any reason. The reasons have to be in terms of my lord lease deed. There is nothing. Kindly, my lord, come to page 157. This is the
So that
final
is what
act.
they start with. This is
the letter by which they have purported to termination, cancellation of contractual relationship.
so that's the first line. This is in reference to the NBSTC bus terminus situated on the and a purported notarized agreement to lease executed.
Yes.
So here also they have stated that it is notarized agreement to lease. They have not recognized your registered deed of lease.
How can they not register? Because that document is signed by them.
And then a further purported supplementary agreement executed in your favor on 31st of October 2003.
Yes.
The purported power of attorney executed in favor
Everything
of
purported, naturally, my
And-
lord. Nothing, either purported or pretended or alleged. Three things we have learned, my lord, we have joined the profession. And my lord, these are the three, right? Purported, alleged, and yes. So, my lord, these languages are purported, everywhere purported. And my lord, kindly see, you are made fully aware and you are aware that we, in our affidavit in opposition filed in response to so-and-so, had stated to give you notice that we had in our 200, what is the reason? That we had in our 216 board meeting held on 30th November, for very many reasons, had decided to terminate and cancel. This is a cancellation of a document. My lord, they have forgotten, my lord, the Transfer of Property Act. Had decided to terminate, cancel the said purported agreement dated so-and-so and dated so-and-so, and the purported registered agreement dated so-and-so as also purported power of attorney, everything purported. At the said meeting, a resolution is also adopted to such effect, and also to revoke the said purported power of attorney dated so-and-so. You duly accepted the said notice and took inspection of the minutes of the board meeting, etc., passed by the Honorable High Court. Need to obtain so-and-so, so-and-so. The said inspection was obtained when the advocate record.
So I believe this paragraph B is the, this is a cause of action for the second writ petition.
This is the third writ petition.
So this one is for the second one.
No, second.
On 21st of January 2016, the inspection was obtained by your advocate on record along with your representatives on or about 3rd of February 2016.
This is the 216 board meeting. Inspection
So
of
that would be for the second writ petition.
They disclosed it in the second report.
This disclosed it in the second writ petition. I challenging the third writ petition. Lord, one after the other writ petition. The first one is challenging the action of NBSTC. Second writ petition is challenging the action of Calcutta Municipal Corporation. Third writ petition is challenging the action of the state of West Bengal. And then, this is the only reason. A and B, in spite of the aforesaid, you wrongfully, illegally, instead of handing over possession, so and so. How can it be cancelled? Transfer of Property Act, they have forgotten about it, or they have not learned about it.
So they have revoked the power of attorney also.
How
So
can
then
they do it?
how can you,
They will have to file a suit for cancellation of it. Registered power of attorney has to be cancelled by a registered document. And registered lease, it cannot be cancelled excepting in terms of section 111. May I hand up to your lordship?
So you have exhaustively stated that.
Yes. So therefore, my lord, kindly see, therefore, you are determining a lease, a registered lease. And is this the way you do it? My lord, even my lord, a first year student in LLB will know, my lord, how to cancel a lease. And I refuse to believe, my lord, that the state of West Bengal doesn't have the lawyers
But then, sir, they say that it is for the public interest. They want the property back.
What is the public interest?
That is what they have stated.
I'm sorry, my lord, public interest is not one of the grounds under section 111. If you want to cancel, if it is a public interest, you come to court. You say that this is the public interest, set it out and request the court to cancel it in public interest. So you don't come to court, you pass it in 216 board meeting, you pass a resolution and cancel it.
They have mentioned about a public interest litigation being WP number 7987W of 2002, directing shifting of the bus terminuses from Esplanade in terms of the recommendations of a high power committee formed in the same public interest litigation earlier. Since NBSTC has no other suitable property in and around the city of Kolkata, it was decided to utilize the captioned land in its Ultodanga bus terminus to accommodate inter alia buses which otherwise would have been parked at Esplanade terminus.
My lord, this is what they have said. No, I asked this question.
So this is in page number 150.
Yes, I know. This is what they have said. Not in the 216 board meeting. I do not know what 216. What I am on is something totally different. I say that if you want to cancel a registered deed of lease, should you not give me a hearing? I relied upon Mahinder Singh Gill. It is loud and clear that when you are affecting my interest, my lord, civil interest, then my lord, I am entitled to a hearing. You do not show me what the public interest is. You do not give me a hearing. You do not disclose your so-called public interest, and then you cancel it in the 216 board meeting. I am questioning that. You may have a good ground to cancel. You may have, but the procedural impropriety is, and this is what I'm on. Procedural impropriety is this: you are not letting me know what it is about. You are not giving me an opportunity of hearing. You are not giving me even a written explanation as to what this is all about. And then you are cancelling it, and then you are saying you get out of it. What will happen to my kindly, my lord? I am do not take it, my lord. I am putting a question to yourself. This is a question I am putting to my learned friends to answer. What is going to happen to my 13.6 crores I have expended? What is going to happen to the development I have made onto the land, whatever development I have made? What is going to happen to 2 crores of rupees I have paid to the KIT? What is going to happen to my the land rent, ground rent, the ground rent which I have paid more
You
than
have paid for 99 years.
99 years I have paid. They have accepted the money, pocketed the money, and then they can turn around and cancel. Well, I do not understand this. That how can they justify that kind of an action?
We have not accepted. We have returned.
Return when? What return? 1 crore, 1,86,000. Where have you returned? Where is it?
That was ground.
Ground, that is ground, and who has pocketed? They have taken. KIT has taken that. It is not by NBSTC. Ground end is KIT. That money has not been returned. So you create an interest in me by taking my money. You give me possession. Allow me to, my lord, undertake whatever construction I want to undertake.
Now, you paid for that sanction plan also?
Yes. Entire money has been paid. KMC has pocketed that amount of money. My lord, I just...
They say NBSTC said that they didn't have money. So you have paid for NBSTC.
Yes.
Which they refused to
Which
accept.
they received. The benefit they have received. I have... My lord, this is something very strange. My lord, had it been between private parties, if I have done this to my learned friend, he would have not shown me one court. He would have shown me different courts in this country. If I had done this to my learned friend, I would have been sent to jail. Well, only because my adversary, the government bodies, therefore you allow this to happen. Only because they are government bodies. Kindly note, these are all on record. I am not going into any disputed question of fact.
But sir, they again have said in paragraph 3, first line, in page 157,
yes, my lord,
that you have in spite of the aforesaid, you wrongfully and illegally, instead of handing over possession of the said captioned land to us, you have been wrongfully and illegally pursuing your writ petition bearing number
So I am
such and such.
wrongfully pursuing my writ petition. Therefore, I shall be penalized for pursuing my remedy in court, in a court of law. And your lordship will countenance that. And that is the threat which is being given. And their state. The state is threatening an individual, a citizen, that why have you gone to court? And you have gone to court in spite of the fact that I am purporting to terminate. Normally, I am using the term purporting to cancel this. This is the letter. This is the only letter, the letter which has been given by them. And there is no answer to it. My lord, I expected, my lord, answers from my learned friends to this. No answer as to how a registered lease can be terminated, save and except under section 111. No answer with regard to public interest litigation. Why have you not given me a hearing? No answer as to what is going to happen to the money that I have spent. They should have come and offered that you take back your 13 crores. They should have come back and said that you, so far this ground rent is concerned, take back the money. Well, they have pocketed the money and they say, well, they're behaving not even like a common thief. I'm sorry to say that. Worse than a common thief. I take your money, but I get you out. And this is exactly what they're doing. My lord, I conclude my submissions by only referring your lordship to one judgment which I have already cited. My lord, kindly see what the division bench of the Supreme Court has said. This is given 2020, 13 Supreme Court cases 285. The court should not countenance this thing only because they are the state. Kindly, my lord, take this. The judgment of Justice Chandrachud and Justice Indira Banerjee. It's absolutely loud and clear as to what the law is. I am not troubling your lordship. My lord, what
Paragraph 11.
My lord, paragraph 11, 12, 13, 14. My lord, may I place it, my lord? Kindly, my lord, allow me to place
Yes.
it. Article 226(1) of the Constitution confers on the High Courts the power to issue writs and consequently the jurisdiction to entertain actions for the issuance of writs. The text of Article 226(1) provides that a High Court may issue writs for the enforcement of the fundamental rights in Part 3 of the Constitution or for any other purpose. A citizen may seek out the writ jurisdiction of the High Court not only in cases where her fundamental right may be infringed, but a much wider array of situations. Lord Coke, commenting on the use of the writs by the courts in England, stated, "The courts of King's Bench hath not only the authority to correct errors of judicial proceedings, but other errors and misdemeanors." Kindly note them. What I am saying, I am alleging misdemeanors against my learned friends' clients, tending to the breach of peace or oppression of the subjects, or raising of faction, controversy, debate, or any other manner of misgovernment, so that no wrong or injury, public or private, can be done, but that this shall be reformed or punished by the due course of law. Kindly see, my lord, therefore, so that no wrong or injury, public or private, can be done. Then, echoing the sentiments of Lord Coke, this court in UP Sugar has said this: "It is well settled that the jurisdiction of the High Court under Article 220 in the Constitution is equitable and discretionary. The power under the article can be exercised by the High Court to reach injustice wherever it is found." Your Lordship, my lord, has got tremendous power. And my lord, Supreme Court has said that the power of the High Court under Article 226 is even wider than Article 32, the power of the Supreme Court. Kindly, my lord, then come to 13. The role of the High Court under the Constitution is crucial to ensure the rule of law throughout the territorial jurisdiction. In order to achieve these transcendental goals, the powers of the High Court under its writ jurisdiction are necessarily broad. They are conferred in aid of justice. This court has repeatedly held that no limitation can be placed on the powers of the High Court in exercise of the writ jurisdiction. In Venkateswaran versus Ramchand, A constitution bench of this court held that the nature of powers exercised by the High Court under its writ jurisdiction is inherently dependent on the threat to the rule of law. Threat to the rule of law, every word is important in this, arising in the case before it. And then it quotes, we need only to add that the broad lines of the general principles on which the court should act, having been clearly laid down, their application to the facts of each particular case must necessarily be dependent on a variety of individual facts, kindly note this, which must govern the proper exercise of the discretion of the court, and that in a matter in which this preeminently one of discretion, it is not possible, or even if it were, it would not be desirable to lay down any inflexible rules which should be applied with rigidity in every case which comes up before the court. The powers of the High Court, and this is what the Supreme Court says, in exercise of its writ jurisdiction cannot be circumscribed by strict legal principles so as to hobble the High Court in fulfilling its mandate to uphold the rule of law. While the power of the High Court may exercise under its writ jurisdiction are not subject to strict legal principles, two clear principles emerge with respect to when a High Court's writ jurisdiction may be engaged. And kindly note this. First, the decision of the High Court to entertain or not to entertain a particular action under its writ jurisdiction is fundamentally discretionary. Secondly, limitations placed on the court's decision to exercise or refuse to exercise writ jurisdiction are self-imposed. It is well-settled principle that the writ jurisdiction of a High Court cannot be completely excluded by statute. If a High Court is tasked with being the final recourse to upholding the rule of law within the territorial jurisdiction, it must necessarily have the power to examine any case before it and make determination of whether or not its writ jurisdiction is engaged. Judicial review under Article 226 is an intrinsic feature of the basic structure of the Constitution. Then, my lord, kindly come to para 17. This every paragraph, my lord, I find is something we should learn from. The observation extracted above, my lord, this is from Sangram Singh's case, the famous case of against election tribunal. The observations extracted above raises an important consideration with respect to the present case. If by the self-imposed rule, the writ jurisdiction of the High Court is circumscribed by the existence of a suitable alternative remedy, and this is what they have urged before your lordship, by a suitable alternative remedy, whether constitutional, statutory, or contractual, then the High Court should not exercise its writ jurisdiction where such an alternative remedy exists. Thus, before we address the question as to whether or not Clause 21 of the Constitution bylaws compel the Bombay High Court to abstain from entertaining the appellant's writ jurisdiction, we must first address ourselves as to whether, even in the absence of Clause 21, the existence of an alternative remedy would create a bar on the Bombay High Court entertaining the appellant's writ jurisdiction petition. My lord, I pause here for a moment. I tell you what happened in this case. There was a dispute between the parties. The parties had entered into an agreement. There was a clause in that agreement that in case of dispute, the matter will be referred to arbitration in Madras, in Chennai. That was the clause. When the matter came before the Bombay High Court and constitutional questions were raised, Bombay High Court said there is an alternative remedy provided under the Arbitration Act. You go to arbitration and before the Madras Court, Chennai High Court, not before me. Mala dismissed the application. Supreme Court is reprimanding the Bombay High Court. Kindly see the next paragraph. The case of the second respondent is that the dispute should be heard and decided at Chennai. It follows that if the respondent's argument is accepted, the High Court of Madras would hear the present matter. Therefore, the alternate remedy, that is the writ petition before the High Court of Madras, is equal in every way to the present remedy sought by the appellant. This is what was argued. The High Court of Madras is imbued with the same powers in the exercise of its writ jurisdiction. The submission on the above premises is that the appellant can avail of the same relief at Chennai as it is in Mumbai. Hence, the agreement between the parties must prevail, and the writ jurisdiction of the Bombay High Court under Article 226 stands ousted. Then, my lord, the Supreme Court is saying this. This argument of the second respondent is misconceived. The existence of an alternate remedy, whether adequate or not, does not alter the fundamentally discretionary nature of the High Court's writ jurisdiction, and therefore does not create an absolute legal bar on the exercise of the writ jurisdiction by the High Court. The decision whether or not to entertain an action under the writ jurisdiction remains a decision to be taken by the High Court on an examination of the facts and circumstances of the particular case. Even though, my lord, a specific provision, I shall show to your lordship the provision, specific provision was there. Kindly come to paragraph 2. Article section 21, or rather clause 21 has been set out. Kindly come to paragraph 2. This was in the agreement itself. Parties had agreed that any suit or legal action against federation shall be instituted only in the courts in Chennai. And, my lord, Chennai, my lord, in the Bombay High Court, the institutional proceedings were instituted. And, my lord, the Bombay High Court said that no, there is an arbitration clause, agreemental jurisdiction, therefore go before that court. Supreme Court, my lord, castigated that, frowned upon it. He said, no, you couldn't have done that. And he said that the existence of an alternate remedy, whether adequate or not, does not alter fundamentally discretionary nature of the High Court's writ jurisdiction, and therefore does not create an absolute legal bar on the exercise of the writ jurisdiction of the High Court. The decision whether or not to entertain an action under writ jurisdiction remains a decision to be taken by the High Court on an examination of the facts and circumstances of the particular case. Then, my lord, it's UP state spinning, my lord, that has been quoted. Kindly see this, para 20. Except for a period when Article 226 was amended by the Constitution, 42nd Amendment, the power relating to alternative remedy has been considered to be a rule of self-imposed limitation. It is essentially a rule of policy, number one, convenience, number two, and discretion, and never a rule of law. Despite the existence of an alternative remedy, it is within the jurisdiction or discretion of the High Court to grant relief under Article 226 of the Constitution. And then, my lord, what happened in this particular case? This order of the Bombay High Court sending it to Chennai.
It again says, at the same time, it cannot be lost sight of
Yes.
that though the matter relating to an alternative remedy has nothing to do with the jurisdiction of the case, normally the High Court should not interfere if there is an adequate, efficacious alternative remedy.
In this case, arbitration proceedings. Clause, my lord, the specific clause giving, my lord, Chennai High Court.
So if we come to paragraph
ultimately, my
17,
lord, you know what happened in this?
sir,
Yes,
for my
yes.
clarification, so if you come to paragraph 17 once.
17.
17.
Yes, yes.
It says, if by the self-imposed rule, the jurisdiction of High Courts is circumscribed by the existence of a suitable alternate remedy, whether constitutional, statutory, or contractual, then a High Court should not exercise its jurisdiction where such an alternate remedy exists.
Yes.
Now, sir, when you are saying what will happen to my 13.6 crores or the money that I have spent, so now for them it is the public interest, they want the land to be back, and they are not also in a position to even utter a single word on the amount that you have paid. Now they might as well pose the question that you want to get back the money, you have an alternative efficacious remedy, you better go and file a money suit. So then what would be your answer?
What about my possession of this? Well, I am concerned today not with the money aspect of the matter. None of this, my relief claim is with regard to return of the money. My case is this, that you have exercised your power in a manner which is not, my lord, in accordance with fair play.
Because that is their moot question, that this is a contractual issue, this is beyond the jurisdiction of this court to deal with.
To that I have cited.
Sir, when you have cited this case, let us also try to.
No, of course, I have. What I am submitting is this, that if this particular point had been taken 25, 30 years earlier, it would have met with success. Radhakrishna Agarwal, which they cited, 1977 Supreme Court. But as I submitted to your lordship, thereafter, the law has undergone it, and my lord, has changed so much that this, and now the law here, the constitutional law here, is more advanced than the constitutional law either in America or in my lord UK. This is, my lord, the constitutional law has advanced now. The courts say that the writ jurisdiction of under Article 226 cannot be curtailed. If there is not a fair play on the part of the government has acted in a manner which is not, my lord, above board, then the court has the power to step in and say, put the things right. And as I submitted to your lordship on the last occasion, my lord,
Sir, in this judgment also there is a paragraph, I believe. 22,
yes,
21 and 22.
not 22, kindly come to
22.
the mere existence of alternate forum, whether the aggrieved party may secure relief, does not create a legal bar on the High Court to exercise its writ jurisdiction. It is a factor to be taken into consideration by the High Court among several factors. Thus, the mere fact that the High Court at Madras is capable of granting adequate relief to the appellant does not create a legal bar on Bombay High Court exercising its writ jurisdiction in the present matter. And, my lord, in spite of, my lord, the arbitration clause conferment of jurisdiction on the Madras High Court, the Supreme Court set aside the order. Supreme Court said that no, Bombay High Court must consider from the legal point of view. Kindly see this. Para 23. Kindly come to para 23. This brings us to the question whether clause 21 itself creates a legal bar on the Bombay High Court exercising its writ jurisdiction. Well, this is the alternate remedy, clause 21. As discussed above, the writ jurisdiction of the High Court is fundamentally discretionary. Even the existence of an alternate remedy is merely an additional factor to be taken into consideration by the High Court in deciding whether or not to exercise writ jurisdiction. This is in marked contradiction to the jurisdiction of a civil court, which is governed by the statute. In exercising its discretion to entertain a particular case under Article 226, a High Court may take into consideration various factors, including the nature of the injustice. My lord, kindly note this. The nature of the injustice that is alleged by the petitioner, whether or not an alternative remedy exists, or whether the facts raise a question of constitutional interpretation. My lord, if I may read this sentence again. In exercising its discretion to entertain a particular case under Article 226, the High Court may take into consideration various factors, including the nature of the injustice that is alleged by the petitioner. I am alleging what? I am alleging that you have given me this particular land, you have allowed me to develop this particular land, you have taken money from me, you have allowed me to submit a plan for which I had to pay a huge amount of money to Calcutta Municipal Corporation. So many other government bodies are involved in the entire transaction. This is, my lord, the nature of the injustice that is alleged by the petitioner. This is what I am alleging before your lordship. These factors are not exhaustive, and we do not propose to enumerate what factors should or should not be taken into consideration. It is sufficient for the present purposes to say that the High Court must take a holistic view of the facts as submitted in the writ petition and make a determination on the facts and circumstances of each unique case. What it says is this: the High Court cannot just ipse dixit, so to say, abandon its jurisdiction to decide this issue. Each case has to be decided on the basis of the facts as to whether injustice is being suffered by the petitioner or not. That is the basic issue. That is the basic question. And that is why in paragraph 26, kindly see what it says. In the present case, the Bombay High Court has relied solely on clause 21 of the Constitution and Constitution and bylaws to hold that its own jurisdiction is ousted. The Bombay High Court has failed to examine the case holistically and make a considered determination as to whether or not it should, in its discretion, exercise the power under Article 226. So in spite of the fact there was a jurisdiction clause, in spite of the fact that the Madras High Court has been given exclusive jurisdiction, even though there was an arbitration clause, the Supreme Court says no, Bombay High Court cannot just abandon its power and abdicate its power, actually abdicate its power, and my lord, leave it to the Madras High Court to decide this issue. Bombay High Court should have decided as to whether this alternative remedy should be allowed or not. Bombay High Court should have decided as to whether substantial injustice has been caused to the party or not. Once it is found that it's a substantial injustice because, in spite of, my lord, alternative remedy available, Bombay High Court had no reason to abdicate its power in favor of Madras High Court. Well, this is loud and clear. Well, I cannot put my case better than this. I submit to your lordship that looking into the totality of facts, I am requesting your lordship to look into the no evidence is required. I am relying entirely on documents. They are relying entirely on documents. On the basis of the documents, can their action be justified? If their action cannot be justified, writ jurisdiction, my lord, should be invoked for the purpose of striking down what they have done. These are my respectful submissions.
But sir, here in this particular case, as far as the jurisdiction of Bombay High Court and Madras High Court are concerned, where Bombay High Court could have entertained or not, it's not exactly applicable to this course.
It is,
but
no, your lordship
but
is correct.
As far as the contractual part is concerned, substantially that essence can be taken, but not directly with regard to the jurisdiction aspect.
Kindly look at it from this point of view. Your lordship has been. I'm very glad, my lord. Your lordship is putting the absolutely pertinent question. My lord, my respectful submission is this: that if it has been looked on the basis of the contract, clause 21 is there, staring them at the face. So undoubtedly, indisputably, Madras High Court would have jurisdiction. Bombay High Court would not have jurisdiction.
Sir, mainly 17, paragraph 17 and 22 in conjunction.
In conjunction, my lord, kindly look at it from this point of view. That if clause 21, there's an arbitration agreement. There is a contract, civil contract between the parties. The clause says that Madras High Court will have jurisdiction in case of any dispute. Clause says in case of any dispute, matter will go to arbitration. So there are two impediments. One is, my lord, jurisdictional clause, Madras High Court. Another is procedural clause, not suit. Has to be no arbitration, no 226 arbitration. You go before the arbitration. Bombay High Court naturally said that these two clauses are staring me at my face, so I shall send it to Madras High Court. Madras High Court will decide in what arbitration proceeding the matter will be resolved. Bombay High Court washed its hands off. Matter went to the Supreme Court. Supreme Court said no, Bombay High Court shouldn't have done it. Here the question of not a constitutional question. It's a question, statutory question which is causing injustice to the parties. Why should the Bombay High Court not look into it? Why should the Bombay High Court only rely upon the alternative? This is why I am saying it's a very strong case between two high courts. And my Lord, Supreme Court condemned the Bombay High Court for my Lord abdicating its role, abdicating its power, and giving it to the country. If struck it down, send it back to the Bombay High Court. Decide the two points. Don't shut your eyes.
Okay, sir.
This is like simple subject.
My lord will kindly recall.
No, I'm not shutting my eyes. Not that way. Not.
Your lordship's mind is absolutely yes. I'm very glad, my lord, that you are please to put me these questions so that I could also, my lord, try and clarify it to the best possible way.
I am not much on that jurisdiction aspect as far as this particular case is concerned, but more on that contractual aspect, which has been clarified in paragraphs 17, 21, 22, and 23. That would suffice.
I will submit to your lordship. Can you repeat these documents?
The documents which are there in the compilation, these documents will answer the question.
My stand, my lord, may kindly recall that we are not also supporting the NBSTC. I am on 95 agreement, the original lease agreement, in violation of which the entire exercise was done. So on that aspect, I have submitted. And so far that clause is concerned, my lord, subject to correction, my learned senior friend has not addressed on that.
Which I have addressed on everything. What is
What would
Clause.
happen? What would happen to that agreement 95 agreement clause 7 and 12(1)?
Clause 712(1).
Clause 7. Page 9, if you lordship kindly have a look. Page 9. I submit just to remind your lordship, my lord, I have
Let me see, because
clause 7. Clause 7. Where without permission, what could not have been done by the NBSTC without the permission of the KIT?
oh,
After all this,
sir, what about those letters where you told,
That on that I have submitted.
then sir,
On
you
that
were sitting and smiling?
no, on that I have
Yes, sir.
submitted that. On that I have submitted that was not in favor of MA. This petitioner. We
I am issuing the check with one expression on that. We are accepting the check, pocketing the check, and then you are saying it is not.
you have paid on behalf of
So
NBSTC.
you have disowned NBSTC.
Yes. So far this violation part is concerned. They could not have done it.
And then what about the letters exchanged between you and NBSTC?
In no cabinet decision on that I have made submission. That is not binding on us. That is not binding on us. Why not binding? My lord, I have made submission on that. Why are you laughing? We are on that. Why it is not binding?
You should support him instead of discouraging him.
Why that is not binding on the KIT? On that, my lord, I have made submission. And so
And you
far,
will say that you have not addressed those letters to NBSTC.
NBSTC, that for developing what permission was given, permission was conditionally given, subject to payment, which payment was not made within the prescribed period. That permission, that what we have given, that dies
Natural death.
natural.
But I keep the money in my pocket.
It is the NBSTC who will compensate, if any.
Ooh.
Why should we? How?
We all heard that particular story. Kanamachi. You die is sort of banned on the eye and then live
To catch hold.
and everybody fled. And this is exactly what is
So now he is.
I'm trying to touch
He has disowned NBSTC. He has disowned the correspondences with NBSTC.
Correspondences, I'm not disowning, but NBSTC could not
So
fulfill the terms.
if there is a probability, then
But
you are not in a position to be liable. That's
the
what you
cabinet,
exactly want to
but
say.
the cabinet decision cannot bind us. The ground I have placed below.
I have got nothing more to say, but we are all very grateful to your lordship for a very patient. But I am sure, my lord, and if that short temper would have thrown the civil procedure court act. But thankfully, my lord, your lordship did not do that. We are very grateful.
No, sir, there are people here who have contrary views also.
I mean, আপনি যে সংখ্যার মধ্যে আছে তাদের জিনিস তার অবস্থানে almost nobody can repeat him on verbal আপনার আর বাড়াবেন না when I leave the corridor, I try and verbal ones are
Sir, you had on the earlier occasion said you will file a note, will you? I mean,
short note I just find the points.
So all the parties.
if you can, if you want.
আমি খাটবো তোমরা করবে
So note
How long will you take, sir? Okay.
with judgments or simply note.
So if you give another copy, then it will be easy for me to compare with the ones which are already there on record. Though I have noted down, but it will be easier for me.
by learning to along with the note, we shall include the
A copy, because I don't know whether it will get misplaced or not. Though I have written down if I get a copy, it will be better. So aside matter. Next date, 24th. So 15th of December will do. Next week, so 15th of December. What is the number of? দেখি রেকর্ডটা কত নম্বর এটা? এই রেকর্ডটা দেখি কত নম্বর? যদি 3:30 যদি প্লিটা নেয় তাহলে রেকর্ডটা থাক, আর যদি তাও চায় তাহলে কিন্তু দুঃখ আছে কপালে।
Lordship, since morning he is suffering. He told me that.
What?
Since morning he is suffering. He told me that he is suffering from
Suffering
cough
what? He's
cough
not
and cold.
suffering anything.
He is suffering from cough and cold. বলছি বিশ্বাস করো না। না না হচ্ছে না দাদা।
না দেখি কত নম্বর অ্যাডজর্নমেন্ট চাইছে ওটা দেখি। এটা না, এখানে অর্ডার নেই।
না না অন্য করছি। Lordship, he has started his argument on the last occasion. মনে তো বলছি।
I will give the record to you. You will count the number of days.
Yes, no objection.
You are the one who creates objection.
What is your Hey, right?